All right. Hello, everybody. DUI Guy is back with some more content. Let's wait until people join up here. Can you all hear me okay? I have my Yeti microphone and my Logitech camera hooked up. You guys can hear me? Okay, perfect. Excellent. Beautiful. Hello, everyone. Hey, Flotog. Hey, Ziggy. Hockey Canada 25. Hello, Atik Afzal. Hello. Good evening, Arizona Bug. Is it raining where you guys are? It is raining cats and dogs out here. It is raining cats and dogs out here. It's crazy. So much water coming from the sky. So much water. VS Industry. Hello, my man. Atik Afzal, you go to court and you beat him. Hey, Toyopa, Texas. 28 degrees in Toronto, no rain in California. It never rains in California. That's why there's a drought there, I guess. I'm not sure. 90 and hot. Is that Florida? Bruce? Ha 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 ha. Robert DeSell with the puns. Don't step in a poodle. If it's raining cats and dogs out there, you got to be careful. You'll step in a poodle. Slow down, homie. That's right, Pug Lover. That's how you beat speeding tickets. Don't get them. Major flood. Where are you at, Leanne? Where are you at? '94 in Florida. Yes, I'm in Kentucky, Jamie. Oh, you guys want to see my doggy? She's here. I can hear her behind the door. 1 second. Beanie. There she is. There's the little pup. Come here, you little poodle. I gotta be sure not to step on you, because it's raining cats and dogs outside. Because it's raining cats and dogs outside. Oh my God, they're so sweetest, I swear. Look, Beatty, you're famous. No, she doesn't care. She's sniffing for food. She's sniffing for food. She's like, I don't see any food around here. Aww. Oh, okay, well, no food. We're just gonna lick your finger then. Oh, you guys can hear the thunder? Man, this, I'm telling you, it's the Yeti microphone. It picks up everything. I really like this microphone, and I brought it for use today so that we're going to be able to get started here. And I'm streaming this live on YouTube. I've debated whether or not I want to start cross streaming, maybe also stream it on Facebook or something. I don't know. I haven't really decided yet. I've just been doing YouTube for over a year now, I feel that she's just licking my fingers. Can you guys see that? And then now she's going for the face. Facebook, isn't Facebook dead? I don't think it's dead, but I've seen a few people cross stream and they do it like on Facebook and YouTube. But I've been posting on YouTube for so long that I don't know. I just never really even thought about it until I saw his video, and I was like, well, it was the Pot Brothers at Law. You guys know those guys? The Shut the F Up Friday. I don't want to swear on stream so that I don't lose monetization, but You know what I'm talking about. If you haven't, look at their tip of the day, Pot Brothers at Law, POT Brothers at Law. Yeah. What are we looking for? Does my breath smell like food? I think my breath smells like food. Don't forget to like this video, comment, subscribe to the channel if you haven't already. Let me go release her so we can get down to business. All right. Oh, thank you, Fanfic Rocks. I haven't even started yet. Already I have $5 Australian worth of coffee in my pocket. Look at that. What extra considerations do you make with the court in regards to those with autism? I very rarely represent people with autism, so I don't have that much experience with that. Fanfic Rocks. Can do DUI checkpoints in Indiana. They used to, with someone fought it years ago in the Indiana Supreme Court, ruled in favor of the citizen. Quite possible, Real Ricky. I don't know every single state's laws on the issue. Wash your thumbs and hit that like button, people. Okay, I'm still waiting for a few stragglers to come in here. Looks like we got about 45 people watching, but we haven't started yet. It's going to be a fun topic. This is going to be a really, really interesting and fun topic, I think, for everybody. We're talking about constitutionality of roadblocks is what we're going to be talking about. And this is something that the Supreme Court, the United States Supreme Court, has struggled with for quite some time, actually. If you look at the history, it's such an infringement on your basic Fourth Amendment rights that they had to literally bend over backwards to find an exception to the Fourth Amendment. And the way they did that, as you will see in a moment, is the minimal intrusion that basically a road stop and frisk, if you will, like a Terry stop, it requires such a minimal intrusion into your well-being to where it outweighs your Fourth Amendment right to not be searched or seized without a warrant. As you will see, it's very, very, very sneaky how the United States Supreme Court and even the state courts have gone about it, at least in Kentucky, which again, we'll talk about the seminal case, which is Cox v. Commonwealth, and a few of the Supreme Court cases on the issue. So I think we're just about ready to get started. Looks like most everybody is already here who's going to join us, and then we can pick up some stragglers along the way. So as we always do, by introduction, I am Larry Forman, the DUI guy. As you can see behind me, that's my phone number, 844-4DUI-GUI. For those of you who don't know me, what was that? That might be still thunder outside, I swear. It feels like it's coming from everywhere. So I specialize in DUI cases, and we are en route to reopening our firm, at least part-time, as courts reopen on June 1st, which is going to be next Monday. This Monday is Memorial Day, so we're going to have a short week, I guess, 4 days here. Restaurants and bars are already opening all across Kentucky. Very excited about that. People are out and about. Let's be honest, they're drinking and driving, so that's going to drive up business. So I do have a personal vested interest in the same, even though I wish they didn't, but people are going to be people and they're going to do what they're going to do. And they're going to eventually need me. And when they need me, they're going to call me and they're going to hire me and they're going to pay me and I'm going to represent them in court. That's just the name of the game. It's always been the name of the game and it's going to continue to be the name of the game until either people universally stop getting intoxicated and getting behind the wheel of a car, or even if they don't, police officers will always find a way to pin a DUI against you if they even remotely suspect you're taking prescription meds, or maybe you're a little hopped up on caffeine like that guy in California a few months ago. Officers are tricky. They will always find a way to pull you over. They'll always find a way as to how to charge you with a DUI, even though a DUI may not be anywhere near merited in your case. Thank you for another $5 Australian, Fanfic Rocks. Some are not from the US and may not be familiar with what I'm talking about. I'm only talking about Kentucky and the United States, fanfic rocks. So remember, I don't care if you're from Arizona, Australia, Germany, or Pluto. I'm talking about the United States law. So that is a caveat. That is very important for you guys to know. I'm talking about Kentucky. I'm talking about specifically only the Commonwealth of Kentucky, and we'll obviously be brushing up on United States law. So there's a lot of, when it comes to DUI checkpoints, their constitutionality, the United States Supreme Court has pretty much established rules and guidelines for states to follow. Now, every state has kind of mended and bent their constitutionality of Roadblock's rules their own way. Kentucky is a little bit, it's kind of on the fence, as you'll see. It's not as strict, but it's not as relaxed either. And the latest Kentucky case on the issue, a good friend of mine by the name of Greg Sims, great litigator and defense attorney. It was his case, and it went all the way to the Supreme Court, and the Supreme Court ruled in his client's favor, stating that in that particular case, in Cox v. Commonwealth, the constitutionality of the road stop was violated, and therefore the case was dismissed because all the evidence was suppressed. There's nothing left to litigate. So let's dive right in. Where does it all come from? Obviously, let's get to the basics. The Fourth Amendment to the Constitution, the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures shall be violated, and no warrants shall issue but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is a fundamental right. It's in the Constitution. It's in the Fourth Amendment, and that's one we're all familiar with. So this is basically where this all comes from. Obviously, it doesn't mention cars because this is 1776 when the document was signed. They didn't have motor vehicles yet at that point, but essentially later on, obviously that includes motor vehicles as well, even though they're not named exactly. Their persons and effects, I suppose, could be extrapolated to that just from the direct language. So if you don't have probable cause, an officer cannot stop your vehicle. So we've all heard there's a case called Wren v. United States. If an individual, thank you for another $5 Australian fanfic rocks. I'll try to keep it simple, but again, there's certain things that are unavoidable if we're to talk about the law in sufficient manner. So if the officer does not have probable cause to stop your vehicle, then they can. And we all heard, maybe I say I'm referring to law students. I'm sorry. Some of you may have heard there's a case called Wren v. Commonwealth, which stated that pretextual stops are okay, but they may not be roving stops. So an officer can't just be sitting in his cruiser on board, so I'm just going to pull this vehicle over and see what happens. They have to, hey, Bob, thank you for the $4 coffee, man. I really appreciate it. So they have to actually have probable cause to pull you over, a reasonable suspicion of a crime to pull you over, probable cause to search, all the basics. So now we're talking about the constitutionality of a roadblock stop, right? So what is a roadblock? A roadblock is something that the government, the police, the local police, will set up in a location where they will set up either barriers or cones. Sometimes there'll be signs, and if there are no signs, there are other issues with that, constitutionality issues, which we'll get to in a moment, which should alert motorists to the fact that there is a roadblock up ahead, right? And the Supreme Court seems to be kind of universal in the sense that this cannot be inescapable, meaning you should have the ability to turn your car around. Now, of course, you turn your vehicle around when you see a sign that says roadblock ahead, you can bet your sweet butt that an officer is paying attention, and when they see that car turning around, they're going to get into their cruiser and they're going to follow you until you violate the law. So like I said, pretextual stops are okay. He's out to get you. All he's waiting for is one law violation, one traffic violation. You didn't use your blinker when you turned left. You didn't stop 3 seconds at the stop sign. Or the easiest, your license plate is not illuminated. A lot of times your license plate is illuminated, but they simply claim just because they got nothing else. They check your registration, damn it, it's current. I can't stop him for that. Man, he's obeying the speed limit. That's really unfortunate. He's using his blinker. Okay, this is really frustrating. How do I get him? You know what? I'm just gonna say his license plate was not illuminated and I'm gonna pull them over. Happens all the time. All the time. It's the easiest violation. It's very difficult to prove unless there's body cam video and or dash cam video to show that the license plate was indeed illuminated. I mean, that will make the whole case fizzle very, very quickly, especially if that's the pretext of the stop. But if you turned around and checkpoint, let's be honest, you're probably under the influence of something and you're scared because you don't want to get checked by police. So you thought, I'll just turn around and leave. Well, the officer decided to follow you and now they're out for blood, okay? So pretext is okay. The Supreme Court has said pretext is okay. They can stop you when their pretext is, we want to stop that car and we'll find a way to stop it. As soon as they find a way to stop it, boom, they got you. The investigation begins. They have a DUI case, and you won't even be able to argue the constitutionality of the roadblock stop. Why? Because you left. You turned around. You didn't stop at the roadblock that you were supposed to stop at. You ignored the signage. You listened to the signage and you turned around because you didn't want to deal with the officers on the scene. So if you do choose to go through it, so there's certain minimal guidelines that they must follow. There are certain minimal guidelines that they must follow. And there's a case called, it's out of California. It's a really nice case called Ingersoll v. Palmer. It's a 1987 case, 43 Cal 3rd 1321, where the California Supreme Court, it's a California State Supreme Court, set forth the standards for planning and administering a sobriety checkpoint. Now, again, I don't practice in California. I don't know California law. I just found this case to be very informative and very on point. So these are the guidelines. There are 8 of them. The first one is that there is a decision making at the supervisory level. So what does that mean? A decision being made by higher ups. This is not just a bunch of recruits getting together and it's a Friday night and they're bored and there are no calls coming in and they're sitting around and they're thinking, oh, thank you, Willie Czar. I really appreciate it. Don't forget to thumbs up this video if you like it, and comment below and subscribe to the channel. Hit that notification bell if you haven't already. So the first one, a couple of recruits or a few recruits, they can't just sit around and say, you know what, we got nothing to do. We're really bored. It's Friday night. There are no calls coming in. There's a bunch of drunks on the road right now. Let's go have some fun, okay? Let's go wreak some havoc on the streets of wherever and see if we can set up. We're going to set up a checkpoint right here next to Mom and Pop's, tire shop. And we're all just going to stop every car that comes in, right? Every car that comes in, we're going to stop. We're going to investigate. And if they're drunk, we're going to give them a sobriety test. We're going to pretend like they mean something. And as long as we suspect that they're under the influence, we're just going to arrest them. And there we go. We can rack up some DUIs real quick. Otherwise, this is going to be a busy intersection, right? This is the downtown, let's say, area where they're setting up this roadblock. And now they're out for blood. Rather than having to drive around and look for these stops, now they got them literally. They're coming to them. They're coming to them one by one, right? Can't be done. You can't do that. That's the first factor. It's pretty much universal. The United States Supreme Court has said it. Kentucky Supreme Court has said it. Now California Supreme Court has said it. It must be done from a supervisory level. It has to come from upstairs. It has to come from up top. It can't just be done by a bunch of recruits who have nothing better to do on a Friday night, because those cases are out there. I guarantee if you look hard enough, you will find some of them. I didn't look. It's outside the scope of this discussion. Now, the second factor in these guidelines out of the Ingersoll case is there are limits on discretion of field officers. They're within parentheses, okay? So their rights must be within parentheses. They can't have unfettered discretion when they're on the street, okay? When they're in that roadblock, once we'll establish what other guidelines there are, we'll get to those. But once those guidelines are established, they do not have unfettered discretion to do as they please. There are certain guidelines to guide what they're doing and how they're doing it. So unfettered discretion, not okay. There must be some limits on the officers in the field. That's element number 2. And again, these are, I say element, it's not necessarily an element per se. Again, it's a factor. It's a factor to be looked at. And the more of these they can check off, the better off they are. And we'll get to in a moment, we'll talk about Cox v. Commonwealth out of Kentucky. In Kentucky, they actually narrow it down to about 4 factors, but they lump a few of them together into 1 or 2 or 3, and a total of 4. But the 8 that I'm talking about right now is a very nice breakdown. So I just want to give you all kind of like a nice, solid overview right off the top. So then this is a California case. So limits on discretion of the officers who are in the field, who are actually stopping these vehicles and talking to people. Hello, sir. How are you doing tonight? Where are you going? Where are you coming from? Have you had any drinks tonight? I smell marijuana. I smell alcohol, you know, whatever. The third factor in these guidelines is maintenance of safety conditions. What does that mean, and why is that important? Maintenance of safety conditions is basically referring to officer and motorist safety, okay? Because a lot of these roadblocks are not done downtown where it's well lit and the speed limit is 25. A lot of these roadblocks, and I have 2 of these cases, where these roadblocks are performed on a country road that is curvy, where the speed limit is 55, and people are speeding and going fast, and if there's no signage and there are no safety vests to alert that there are people in the middle of the roadway, you know, police officers questioning other vehicles, and there's no signage, hey, attention motorists, there is a roadblock ahead, slow your roll, do not go 55 miles an hour, slow down. You're going to have some serious fatalities in a lot of these checkpoints, and it would be very, very dangerous, not just for the police over there who are conducting these, obviously, because they're walking in their shoes, they're pedestrians in the middle of the highway, but also for motorists who are coming across these roadblocks. So maintenance of safety conditions is mandatory. Safety vests, helmets. Sometimes I rarely see a case where officers actually wear like construction type helmets or anything like that, because it really won't prevent you from getting run over. It's more visibility. You want visibility. You want a few cruisers with maybe flashing lights. You do want signage. You do want cones, and you do want to set it far enough ahead to where you know, you're not just coming up on the roadblock and boom, you're in it without realizing it. So that's factor number 3 in the guidelines. Number 4, it's got to be in a reasonable location. Okay, reasonable location. Why do they put it in there? Because officers are stupid a lot of times. We all know that. If you put a roadblock, let's say there's a hill and you're coming up on a hill, and you're going to set the roadblock right at the top, not even at the top, you still might be visible. If you set the roadblock right after the cusp of that hill, and you set the roadblock right over here, what's going to happen? People are not going to see it. They're going to be going 55 miles an hour, and boom, what's going to happen? You're going to have a dead officer, you're going to have a dead motorist, or possibly even both. Okay, so we definitely want not only safety, but we also want the location to be reasonable. Okay, that's factor number 4, reasonable location. Also, you don't want to be putting it in the middle of the woods where there are no motorists. Goes without saying, but it's in there. Time and duration, factor number 5 of this California case for the guidelines for checkpoint roadblock. Factor number 5 is time and duration. What does that mean? It cannot be infinite in scope. Okay, you cannot set up a roadblock on a Friday night on January 1st and have it go until February 28th. Okay, that would be unreasonable in time and duration, and it must be limited. It must be limited, as we will see. And usually they're set up and they're taken down sometimes within just a few hours, because it's very easy to do. They just set up a few cones, set up a couple of signs, you know, checkpoint ahead. You've seen those orange rectangular diamond-shaped signs. You set those up. You put on your vest. You get up a couple cruisers with lights on. You have a couple of reserve cruisers in case somebody decides to turn around and you want to chase them down. I mean, it's very simple to do at the end of the day, but we're still not done yet. We're still not done, but they have to be reasonable within with their time and their duration. Okay, so it can't be infinite and it's got to be limited. And as we will see, that time has to be known, and we'll get to that in a moment. There must be some indicia. This is factor number 6 of the California case, as I said, Ingersoll v. Palmer, 1987 case 43 California 3rd, 1321. Factor number 6 is there must be some indicia of official nature that there's a roadblock. Okay, there must be some indicia of an official nature that there is a roadblock. We've already talked about this. There's got to be some signage. Hey, motorist, pay attention. Pay attention. There's a roadblock ahead. Okay, focus. Look at the road. Look, you could possibly run over somebody. You got to slow down. The orange, yellow, no green, obviously. Anything to alert drivers, especially the ones that are driving at night, because a lot of times these roadblocks are set up at night, right? That's when people mostly go out and drink and drive. Rarely do you see a roadblock at 8 o'clock in the morning, although maybe after a concert or a rave or something like that that goes on all night, I could easily foresee in the daytime having these roadblocks set up in a lot of these places. So factor number 6, as I've said, it's got to be, there must be some indicia that, hey, there's a roadblock ahead, and it's gotta be official. It can't just be like a little 8.5 by 11 sheet that just says roadblock with ink pen that nobody can see, right? I mean, that would be completely unreasonable. Although I'm sure there's a case out there somewhere where they tried to pass it off, like maybe they won't notice that there's a roadblock. You know, just have it like taped to a door. Even better, tape it to a door that is completely perpendicular to the road, so that you actually have to turn your head in order to see it. I doubt anybody would be that stupid, but who knows? I'm sure everything I'm talking about that I'm making up off the top of my head has already been done. I guarantee it. Nothing surprises me anymore, and I would not be surprised if somebody's actually tried that. Number 7, we're coming up where there's 8 of them, right? So we're almost done with the main ones. Number 7. The length and nature of the detention. Now, this one is very, very, very important. Not only does it boil down into the 4th Amendment and Terry stops, it also talks about the simplicity of the intrusion and how the intrusion itself, not just the length of holding the roadblock, but the intrusion into your individual liberties as a United States citizen, those must also be curtailed, and they must be narrow, okay? It must be narrow. The length and nature of the detention is critical, because they cannot keep you there for over an hour while they try and create a criminal case against you. It must be boom, 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 boom. They do their investigation, they ask their questions. If they don't have reasonable suspicion of intoxication, they must let you go. And even if they do have reasonable suspicion of intoxication, if they keep you there longer than they should have, while they're doing their dog and pony show, while you're being administered the field sobriety tests, they also can't keep you there for an unreasonable amount of time. There are cases where motorists are asked to sit in their cars, and because they have so much traffic and so few officers, right? And every single one of their officers is currently doing field sobriety tests on somebody. And obviously somebody's got to take these people down to the station, right? They can't ask you to pull over and sit there and wait your turn like you're at a drive-through at McDonald's, okay? They cannot do that. They can't keep you there just sitting for 30 minutes, even though they suspect you're under the influence. Eventually, there's whatever that line is. The Supreme Court has just made it can't be unreasonable. As long as it's reasonable, it's okay, but it can't be unreasonable. It's basically a Terry stop, like I said. The Terry factors would boil down and come into play here. So they can't make you just sit there in the vehicle for an infinite amount of time while they're finishing up their field sobriety test and taking everybody to the station, okay? So if it's a really, really busy intersection with a lot of people that they suspect to be under the influence, they're going to have to let a few go. Now, obviously, in the real world, let's be honest, they probably won't, but you will have a much better case in court, especially if they make you sit there for 45 minutes before they even begin their investigation. I say 45, maybe it's 30. Maybe 20 is okay. Maybe 25 is not. It all boils down to the facts of the case. Unfortunately, we don't have clear guidelines on number 7. And finally, number 8. Number 8 is, and this is the most crucial in my opinion, the most crucial is advance publicity. Advance publicity. It must be publicized. It used to be in the newspapers. Now doing it on a Facebook page or online through a newspaper may or may not be enough. Simply telling your supervisor, as the individual who's, let's say, planning it, let's say a captain is planning this roadblock on Lee and Broadway, okay? A captain is planning a roadblock on Lee and Broadway, and he tells his chief of police, I'm doing a roadblock on Lee and Broadway, chief. And the chief announces it to all of his family members, and he announces it to all of the recruits' family members, and every single one of them is aware, but then nobody else. That is not going to fly. It must be publicized, and it must be public, okay? And again, the limits to that, advanced publicity, as long as the people are aware, that might be enough. I mean, just posting it on the Kentucky State Police website probably isn't enough, because how often do people visit the Kentucky State Police website? Now, if they let WDRB, which is a TV station here in town, and WDRB publishes that there's going to be a roadblock, and by the way, remember earlier we said there must be publicity and it must be done with specificity. They can't just say there'll be a roadblock this weekend. Okay, that's not enough either. The United States Supreme Court said that's not enough. It must be limited in duration, and that limited duration must be publicized. Okay, so if we're doing a roadblock, it's got to be roadblock at Friday, June 3rd at 5 p.m. and it'll go all the way to midnight, let's say. Now you have a limited scope, limited duration. It's going to be on Lee and Broadway, as we said, downtown, and having the signage, having everybody dressed in the proper apparel. All of that is going to allow the roadblock to be sufficiently constitutional for the intrusion to outweigh your personal individual rights to be free from search and seizure. Okay, so that's pretty much it in a nutshell. Now, I don't want to go in too deep into the federal standard, because the state case that we're about to talk about covers a lot of this. So let's talk about Kentucky specifically and the United States. So this is going to touch on two subjects simultaneously. We're going to talk about the Commonwealth v. Cox, or Cox v. it's Commonwealth v. Cox, because so Commonwealth v. Cox, this is a very simple fact pattern. Mr. Cox was driving down the road in Marion County, Kentucky. He gets to a roadblock. They investigate. They smell the odor of alcohol. They perform field sobriety tests. They arrest him, take him to the jail. I believe at the jail he refuses, so they don't have a breathalyzer, but that's besides the point. That's a moot point. Even if he did, it doesn't matter, because he won in the Supreme Court. Now, what happened? Let's go back. So the case gets tried. I told you this is a good friend of mine, Greg Sims, great lawyer, great litigator. I have a lot of respect for him. He's the one who is spearheading this case. He's representing Mr. Cox, and they go to trial. They go to trial in front of a Marion County jury, 6 men and women in Marion County a few years ago. And unfortunately, he's convicted. He's convicted, but Mr. Sims, the lawyer that he is, he appeals it to circuit court on the fact that the constitutional roadblock was violated. Now, I believe he filed a motion to suppress in the district court level. I have to assume that. I don't think it's in the opinion directly. If it is, I missed it. But regardless, the point is, the district court has not granted his motion to suppress, obviously, because if they did, there would be no trial. They denied his motion to suppress the fruits of the poisonous tree. You guys have probably heard that. The fruits of the poisonous tree. Sorry, I was deleting a comment. Come on, B, you gotta be on top of this. Be on top of it. You're my moderator, my man. Come on. So they take the case to a jury. The jury convicts, but the issue of constitutionality of the roadblock, as I said, the fruit of the poisonous tree, if the district court had granted Mr. Cox's motion to suppress, all the evidence would have been suppressed from that case, everything, all the investigation that has followed from the moment that he got stopped in his car would have been inadmissible in court. So obviously he lost that motion, and they went to the circuit court. So after he got convicted, I think he got 30 days in jail, and he got some community service and a fine and everything. So it was not a very good result. I mean, it was pretty bad, but I think the facts were pretty self-explanatory. I think, honestly, if I were in Sim's shoes, I would have done exactly the same thing. Let's try the case first, see what happens. We got appealable issues. If we lose, we go right to appeal, because why appeal ahead of time when you could win at the jury trial level and call it a day? I mean, that's just good, damn good lawyer work is what that is. So anyway, where were we? So it's appealed to the circuit court, and the circuit court agrees with the district court. No violation. It's constitutional. The roadblock is constitutional. Forget about it. That's that. Then they appeal, Mr. Sims and his client, Mr. Cox, they appeal to the Court of Appeals, the Kentucky Court of Appeals, which is the next layer. And guess what? The Kentucky Court of Appeals says this is unconstitutional. The roadblock, in this case, applying the factors from the United States Supreme Court case, which we'll talk about in a moment, applying those factors, this roadblock, this specific roadblock in this case, is unconstitutional. Now, obviously, the Commonwealth was not ready for that. They've been winning so far. They won at the jury trial level. They won on the district court level. They won on the circuit court level. And all of a sudden, boom, they get slapped in the face by the Kentucky Court of Appeals that says unconstitutional, unconstitutional. So basically, that throws the entire case away because, again, as we said, the fruit of the poisonous tree, everything that follows from that stop, if it's unconstitutional, the Commonwealth has nothing left to go on. They must dismiss the case. And so very unfortunate for the Commonwealth, but great for Mr. Cox, because if there's a constitutional violation, Fourth Amendment violation, that's what you get. That's how we win cases. So the Commonwealth doesn't like it, and they appeal. And they appeal to the only court that they can, which is the Kentucky Supreme Court. That's the last line of defense. The Kentucky Supreme Court grants review, discretionary review, and they publish their opinion. This case is from 2012 in the Court of Appeals, but I think it was litigated in like 2010 or something like that. I was still in law school. But this opinion is published. It's a 2013 case, and is when it was brought to the Supreme Court, and it was published December 2015. So all in all, I think Mr. Sims represented Mr. Cox for like 5 or 6 years. So it's crazy how long these cases can take, from literally from arrest to decision in the Supreme Court. But don't forget how many steps there have been. You know, first we started with the stop and the arrest on the night of the arrest, which I'm trying to find if we even have. I don't think we have any dates in this case. I'm sure if I could pull the case itself in CourtNet or in the Court of Appeals opinion, maybe they have more detailed facts. But that's besides the point. I mean, from start to finish, from arrest to going to court, to going to jury trial, well, to having the hearing first in district court, going to jury trial, losing, appealing to the circuit court, losing, going to the Court of Appeals, winning, and then going to the Supreme Court. I mean, that's from arrest to Supreme Court decision, 7 steps. 7 steps, and each one takes anywhere from 6 to 9 months easily. So that's basically how long these processes can take, and it ties up a person's funds, and it ties up their life. It's pretty crazy. It's pretty crazy. So anyway, let's get to Cox v. Commonwealth. I don't have the actual citation. It's a published opinion, but you can look it up. It's 2013-SC-000618-DG. That's the Supreme Court opinion, the Supreme Court of Kentucky, of Commonwealth v. Billy Cox. Now, why is Commonwealth first? Because Commonwealth lost in the Court of Appeals level, and they're the ones who filed an appeal with the Supreme Court, which granted their appeal and listened to it and affirmed the Court of Appeals. And so Mr. Cox won the case. Their only possible remedy at that point would be to appeal to the United States Supreme Court. That's the final step. And they only listen, as we all know, probably, they only listen to constitutional arguments and issues that are important nationwide. And maybe the Commonwealth appealed it to the United States Supreme Court, but the United States Supreme Court denied to take this case because they thought whatever decision has been reached is the proper one and they didn't need to look at it. So that's it. The case was over and Mr. Cox won his DUI. So let's talk about it. Let's see what happened in that case. And we already talked about the facts, and let's see why he won and how these cases should be done, how they shouldn't be done, etc. Thank you so much, Richard. I really appreciate it. I hope Hawaii's treating you well in the sun and the sand. Gosh, I miss the beach. I can't wait to go back somewhere. Anyway, what happened? What happened? So, as I said, he approached a roadblock, Mr. Cox did, and the Supreme Court immediately dove into the obvious, as we already talked about. It's the Fourth Amendment to be, as the court said, the Fourth Amendment to the United States, this is a quote, Constitution mandates any warrantless search or seizure to be reasonable. If there is a search or a seizure and it's without a warrant, it must be reasonable. And as we talked about, for purposes of the Fourth Amendment, as long as the stop is brief and it's within the confines of protection of other motorists on the road, DUI checkpoints are okay because the government, this is a quote, has a strong interest in removing drunk drivers from state highways, and that greatly outweighs the brief intrusion on motorists stopped at the roadblock. End quote. This is all from Commonwealth v. Cox, by the way. So obviously, there's a potential for abuse, and the United States Supreme Court recognized that, so they narrowed down their analysis in a case called City of Indianapolis v. Edmond. City of Indianapolis v. Edmond, 531 U.S. 32. It's a 2000 case. United States Supreme Court is being cited in Cox v. Commonwealth. And it basically said that in addition to constructing, this is a quote, in addition to conducting, the traditional balancing test for reasonableness, courts must also review the purpose of the roadblock. Law enforcement may not impose checkpoints whose primary purpose is to detect evidence of ordinary criminal wrongdoing. Rather, roadblocks must have a primary purpose, such as keeping the road safe from impaired drivers or maintaining border security. Obviously, they're also talking about cases that are near Texas border or New Mexico, where unreasonable searches and seizures, quote unquote unreasonable, what would have been unreasonable here in Kentucky, if it's within 100 miles of the border. There's a case out there that says, look, you don't need any probable cause if you're within 100 miles of the Mexico border, or I'm sure it applies to Canada as well. But typically it's applied with respect to the Mexico border. So Kentucky has looked at a case called Commonwealth v. Buchanan, which is 122 Southwest 3rd, 568, I think. But anyway, Commonwealth v. Buchanan, they're basically citing their own case because the guidelines, the 4 general guidelines I told you we're going to be talking about, California, remember, had 8. They set up 8, but these 4, they kind of lump all those 8 together. So they kind of make it in a nice, neat little package rather than spread them out, which makes it a little bit easier to follow, as you will see. And the court in Commonwealth v. Buchanan offered 4 general guidelines. Okay, and then this is the same court, the Kentucky Supreme Court, citing another Kentucky Supreme Court case. And it said that for law enforcement, there are 4 general guidelines for law enforcement to follow to ensure that Kentucky roadblocks are in line with the Supreme Court's Fourth Amendment analysis. Let's talk about them. Number 1, it is important that decisions regarding the location, the time, and procedures governing a particular roadblock should be determined by those law enforcement officials in a supervisory position rather than by officers who are out in the field. Any lower-ranking officer who wishes to establish a roadblock should seek permission from supervisory officials. Locations should be chosen so as not to affect the public safety and should bear some reasonable relation to the conduct law enforcement is trying to curtail. So right away, we can see this is the first factor. This is just factor number one, taken out of Commonwealth v. Buchanan and also applied in Commonwealth v. Cox. And already we can tell from the decision we just covered in California, this is already covering at least 3, if not 4 factors. There's got to be a location, time, and procedures done by a supervisory officer, and locations should be chosen as to not to affect the public safety and have some reasonable relation to the conduct law enforcement is trying to curtail. I mean, factor number 1 can literally be divided into 5 separate sub-factors, okay? And that's what the Kentucky Supreme Court was looking at in Cox v. Commonwealth. Number 2, the law enforcement, this is again, I'm quoting, the law enforcement officials who work the roadblock should comply with procedures established by their superior officers so that each motorist is dealt with in exactly the same manner. Officers in the field should not have unfettered discretion in deciding which vehicles to stop and how the stop is handled. Again, this is pretty much just one factor, just like out of California. No discretion, no unfettered discretion. They got to be within parentheses, okay? These, subordinate officers are working within limits. They have some discretion, but they don't have unfettered discretion. So their discretion is limited. Number 3, quote, the nature of the roadblock should be readily apparent to approaching motorists. Again, going towards safety, but a separate factor. Approximately, we're on factor number 7 here. At least, quote, at least some of the law enforcement officers present at the scene should be in uniform and patrol cars should be marked in some manner. Signs warning of a checkpoint ahead are also advisable. Okay, this is, again, pretty much just like what we talked about with respect to the California case. The nature of the roadblock must be apparent. You got to have signage and you have to have some type of uniform so that a motorist approaching would see, oh, these are police officers ahead, not some, I don't know, investigative unit investigating a murder or something like that, right? Or just plain citizens who are just goofing off or something like that. And finally, number 4 from Cox v. Commonwealth side and Commonwealth v. Buchanan, quote, the length of the stop. See, this is also a very important and a separate factor. Pretty much the first 5, it seems like they lumped into one of their own, and then the remaining 3, they broke down. So the length of the stop is an important factor in determining the intrusiveness of the roadblock. Motorists should not be detained any longer than necessary in order to perform a cursory examination of the vehicle, to look for signs of intoxication, or check for license and registration. If during the initial stop, an officer has a reasonable suspicion that the motorist has violated the law, the motorist should be asked to pull to the side so that the other motorists can proceed. So the people behind them can't just be asked to sit and wait. Notice how, as I've just noticed myself, there is no discussion about publicizing it to the public. I believe they talk about it separately, but it's not one of the factors, which is kind of amazing to me, which is kind of shocking even. But I think they definitely talk about it sometime later. Because they do talk about media announcements that have not been made. There were no media announcements. The traffic checkpoints were planned, nor were there any signs indicating. So that's what we're going to get to in just a moment. All right. So those are the guidelines. Those are the guidelines that the court has established in Commonwealth v. Buchanan. And those are the guidelines that they're following in this case of Commonwealth v. Cox. So how do they apply it? This is where the real fun begins, right? So let's have some fun. Don't forget, by the way, to like this video, comment below, and subscribe to the channel if you haven't already, and hit that notification bell. So let's have some fun. So how did they apply it? This is what they say. Quote, From a bird's eye view of Buchanan, it is clear that we strongly disfavor hastily arranged highway checkpoints. So right out of the gate, they go, you cannot just, remember we talked about even supervisors getting together on a supervisory position and saying, you know what, we're going to do a roadblock in 25 minutes, boys, huddle up. You know, it doesn't work that way. So right out of the gate, they're saying we strongly disfavor anything that is done in haste. And we'll see why this is important to Cox. It is implicit in our analysis that without the proper planning and notice, this is a quote, roadblocks are susceptible to the type of discretion and intrusion the Fourth Amendment exists to forbid. You can already tell where they're headed. They're headed towards just slamming the cops on this in this case. Without proper planning, roadblocks are susceptible to the discretion and intrusion that the Fourth Amendment, the Constitution, it goes against the Constitution, basically in one word, or in 3 words. It is unclear to us whether those discretion-limiting procedures were adequately performed in this case, right? So they go into the analysis. And they say, Marion County, Kentucky State Police appeared to satisfy the first factor, which we said are the 5, right? And it is undisputed Trooper Walker sought approval from his sergeant. The roadblock's location was selected from a list of pre-approved sites. And we presume, they say, this location was pre-approved because it's related to Kentucky State's police goals to finding intoxicated motorists. Again, there's such a strong assumption. And they even say, quote, so the first factor is apparently satisfied in this case. I'm shocked to read that language because, and they even go on in the next sentence. Well, the Court of Appeals, by the way, relied heavily on this factor in reversing Cox's conviction. So that factor that carries pretty much the entire weight, if you will, of the factors that are mentioned in Buchanan, the Supreme Court is kind of brushing off on them, even though that was the entirety of the Court of Appeals' focus, which is really odd to me. But they reverse on different grounds. So, okay. They say that the Court of Appeals panel found, quote, the limited time difference between placing the roadblock request and the supervisor's approval precluded any meaningful review and supervisory guidance. Not only that, but the supervisor arrived like 20 minutes late to the scene. And that was Trooper Rhodes. So the Supreme Court says, look, we agree that any supervision here is cursory, but we can't say that the Kentucky State Police failed to seek approval from a supervisor. So compliance, and they end on this because they don't like it, but they say the Court of Appeals liked it. So we're just going to say compliance with this factor is ambiguous. I mean, you can tell the court is a little confused, but that's not the factor that they reverse on. So let's call it ambiguous. Okay, fine, Supreme Court. Let's move on. The second factor, they say, is even less clear. There is nothing to suggest that the troopers conducting the roadblock failed to follow any of Sergeant Gibbs, he's the supervisor, direction. But simultaneously, there's also nothing to suggest that he provided any direction in the first place in treating all motorists the same. So we have not one or the other. And because there's no express policy for uniform treatment, the facts show that the troopers did not exercise unfettered discretion in operating the checkpoint that evening. And Trooper Walker testified they stopped every car that approached. So again, they go, the second factor seems to have been satisfied. Reading this is very confusing because you're already going in, you know that they reverse the, well, they affirmed the Court of Appeals that reversed basically the district and circuit courts that ruled against Mr. Cox. So very confusing. Basically, they already got 6 out of 8, and they're getting ready for loss, right? So it's very interesting how this opinion is written and how their analysis dives in. Now, this is the third factor is even more problematic, they say. It is difficult for us, the Supreme Court says, it is difficult for us to imagine how the roadblock is readily apparent to approaching motorists. Let me read that again, because this is pretty much how where the Supreme Court has hung their hat with respect to this case. Okay, let me read that again. Quote, it is difficult for us to imagine how the roadblock is readily apparent to approaching motorists. We consider this factor effectively to require adequate notice, they say. The facts reveal that the Kentucky State Police troopers were already at the roadblock site when Sergeant Gibbs approved the checkpoint, and its operation began almost immediately. So they did it ass backwards. Okay. First they set it up, then they agree on who the supervisor is going to be. Well, let me back up, actually. First they decide this is going to be the site. They dispatch the troops, right? And then they decide who the supervisor is going to be. And then the supervisor arrives and, hey, by the way, boys, here we go. Let's get this started, when it's already been begun. No notice, no signage. And as they say, its operation began almost immediately. So again, they're hinting at the fact that things were done backwards here. The presiding troopers, this is another quote, the presiding troopers did not erect any warning signs down the road to inform vehicles approaching the site, nor did they post any announcements of a proposed checkpoint to the media. There's the signage again. So they kind of lump media and signage. I forgot about that. They lump media and signage kind of in the same. Notice, basically it's notice. Hey, there's going to be a roadblock at this place, at this place, at this place, at this time, right? So signage and media. Again, let me read this. This is how crucial it is, where everything appears on its face to be done properly, except just, a minor thing, which they'll say in just a few moments we'll get to. They'll actually even say that failure to comply with one of these factors does not defeat the constitutionality of the roadblock. You may have several factors that are ambiguous here and there. You may have certain factors that are not met entirely, and still you may have a constitutional roadblock. Okay, they might look at it and say it's harmless error. But in this case, and this is key, so far it looks like they were going 6 out of 8, right, for the most part. And some ambiguity, some unclearness, some lack of clarity, some confusion, but for the most part, it seemed to be okay. But the the Supreme Court hung their hat on this factor, and this is important to show the mindset of the Kentucky Supreme Court. Again, I'm reading the same quote because this is how important it is. The presiding troopers did not erect warning signs. I said any, that's my word. Did not erect warning signs down the road to inform vehicles approaching the site. Okay, so there are no warning signs that say roadblock ahead, motorists, slow down, and nothing of that sort. Okay, number one, violation. Number two violation, nor did they post any announcements of a proposed checkpoint to the media. Two critical violations. Number one, you have no announcement to the motorist who's approaching the site. Number two, you had no notice to the public, hey, that we're going to be conducting a checkpoint on such and such date at such and such time, which again goes into, remember the first words that they said? The hastiness. That's where they really put their focus on, the Kentucky Supreme Court. They are so very much against intrusions into the Fourth Amendment, but they will allow them to continue as long as the rules are abided by. But because the police decided to make no notice, no regard to letting the public know, hey, we're going to be doing this, they just kind of scrambled something together. Hey, troopers, let's go. I say troopers, it's because Kentucky State Police are known as troopers. Troopers that go over there and await orders, basically. And they started setting up this presumed checkpoint, and then they went back and like, okay, so we're going to make this at such and such time. Hey, you sergeant, whatever, you're going to be the supervisor, go over there. And he was late. He arrived 20 minutes after those two already showed up because He wasn't late on purpose. They didn't know who was going to be supervising it at that point, probably. They were still deciding on that, which again goes to show how backwards this thing was. And the Kentucky Supreme Court said, look, we're not okay with this. You cannot in such haste create a constitutional infringement, a constitutional violation, okay? We're not okay with it. We will not let this fly. You need to do your job way better, Kentucky State Police, later on. And this sends a message to all police agencies across the Commonwealth and maybe even the nation. So no signage. This is critical for the Supreme Court. Now, they do say the KSP did turn on their emergency lights at the roadblock and officers were in uniform, but that's not enough to provide adequate notice to approaching motorists. They weren't even wearing any type of vests, according to the opinion. They don't mention it, but there's nothing about them wearing light reflecting vests. The roadblock began almost, quote, the roadblock began almost instantaneously without any apparent concern for affording motorists prior notice, which is the third Buchanan factor, which it mandates. Look, listen to that beautiful language. The roadblock began almost instantaneously without any apparent concern for affording motorists prior notice. They pretty much put all their money on notice in that case, okay? So they're letting the agencies know, look, you want to set up roadblocks, by all means, go ahead. But you got to let the public know where it's going to be. Otherwise, the constitutional infringement is just too great. And these roadblocks will just start popping up all across the country, unfettered, without any discretion, without any constitutional protection. And we will no longer be the United States. The Fourth Amendment will have been evaporated at that point. Because the police will be able to go to any location within a moment's notice, set their troopers or their officers or their deputies in a location, and boom, and now everybody traveling through is now subject to a stop and they don't even realize. I mean, I think it goes without saying what I'm talking about, but you see where this is going. And the United States Supreme Court said, absolutely not, we're not going to be, this is not 1941, okay? Now, finally, this is the fourth factor. The Kentucky State Police seems to have complied with the fourth factor. So they're batting 7 out of 8 here, if you've all been paying attention, is what it seems like. The Court of Appeals cited the undetermined length of the roadblock that night as a central reason for concluding the checkpoint was unreasonable, but the Supreme Court basically seems to say, well, we don't really care. Undetermined durations, maybe this is a quote, undetermined durations, maybe symptomatic of broad discretion. This factor focuses more on individualized stops themselves and less on the duration of the checkpoint process as a whole. But the review of Cox's particular stop reveals it was no more intrusive or necessary than for Trooper Walker to obtain Mr. Cox's license, registration, and quickly ascertain a reasonable suspicion of DUI. So there are many procedural problems in implementing the DUI checkpoint. We can't say that Cox's stop itself was impermissibly prolonged. Again, if you read this decision, and now me rereading it, it just refreshes all these emotions that I had when I read it the first time around 5 years ago. They got 7 out of 8 right, for the most part. They got 7 out of 8 right. And if the only thing that they did was just let the public know, they would have won this case at the Supreme Court level. They may have still lost on the Court of Appeals, but unfortunately, the Court of Appeals is not the last line of defense. So that's not the last line of defense. And if it goes to the Supreme Court, it goes to show the Supreme Court is not okay with these stops being erected, unfettered, with pure full discretion, with no notice, is just completely unacceptable for the Kentucky Supreme Court. So that's basically road stops and checkpoints. And what I think somebody on my channel, I can't remember who it was. I can't remember who it was that said this, but somebody said that these the checkpoints are blanket unconstitutional. Obviously, having sat through this hour-long discussion, you now know that yes, they are constitutional if certain factors are met. So if the factors are met, the stop will be constitutional. If the factors are not met, the stop will be unconstitutional, in violation of the Fourth Amendment. But even if certain factors are violated and others are not violated, depending on what they are, the stop may still be, the roadblock may still be constitutional, thus making the stop constitutional, while others may or may not be, if there are absent, may make the stop unconstitutional. So it's a balancing test. There's no universal application to this. Every state does its own thing. I think somebody mentioned at the beginning of the stream that Indiana has completely done away with DUI checkpoints a few years back, just because they said they're too complicated, they're too unconstitutional, we're not willing to look at this. So there you go. There's another state. So we got 2 now. We know California does allow them, and they apply their 8-factor test. So, of course, Kevin Coburn says a plain reading of the Fourth Amendment. Nobody plain reads almost anything anymore unless it's an issue of first impression. This is not an issue of first impression. There's lots of case law on the constitutionality of roadblocks. So the case law of the United States Supreme Court, of course, controls. And whatever jurisdiction you're in, that case law is going to be the controlling case law in that jurisdiction. So, and Kevin says Michigan too. I'm guessing you are referring to the fact that the roadblocks have been deemed unconstitutional in that state. So the states can erect their own laws and put in their own laws that are going to that go above and beyond the constitutional standard. They can't go outside of it. So they can make theirs more narrow, but they can't make theirs more broad than the constitutional standard, which again are the 8 factors pretty much discussed in both the California case and Buchanan. They're the ones that have been applied and will continue to be applied. So having said all of this, the conclusion was, in case any of you are wondering, nothing in our decision today should be construed to disparage Buchanan or the various Supreme Court precedents legitimizing checkpoints to purge drunk drivers from our highways. We understand the grave danger intoxicated drivers create on the roads, and we presume that law enforcement generally acts honorably in its efforts to protect innocent motorists from the recklessness of impaired drivers. But we must also secure the blessings of liberty. Oh, what such beautiful language. Let me read that again. But we must also secure the blessings of liberty preserved through our foundational documents. Of course, they're talking about the Constitution and the Fourth Amendment specifically. We simply cannot conclude that law enforcement adequately complied with the Buchanan factors substantially enough to render this roadblock a reasonable seizure performed in the absence of a warrant or individualized suspicion. Basically saying, I love how they do a double negative. We cannot conclude that they adequately complied. Basically, they didn't comply. Just go out and say it, but they were hesitant. So in their conclusion, for the foregoing reasons, we affirm the determination of the Court of Appeals. The Cox's arrest and conviction was the fruit of an unconstitutional seizure. All judges sitting, 1 concurred, and I believe 1 dissented. We're not going to get into those. We just wanted to cover the meat. So don't forget, by the way, to like this video, comment below, subscribe to the channel if you haven't already, hit that notification bell if you enjoy this content. I'm live every Saturday at 6:30 Eastern Time, 3:30 Pacific, 4:30 Mountain, 5:30 Central. And if you're in Europe, I don't know, your GMTs and Euro hours, you can calculate those on your own. I think Google can be very helpful in those. So that's it. This is the discussion. This concludes the discussion of the constitutionality of checkpoints in the United States, and more specifically in the Commonwealth of Kentucky. I do want to open the door up for questions. So let's go ahead. Do I have any moderators left in the chat here? B, are you in here? I don't think I saw Kim or Liberty Cause or anybody. I see a couple of tags on my name. Grandmaster level, you may have emailed me, but if I ignored your email, I apologize, but I'm just very busy. It's hard for me to get to everybody. I don't see any other specific tags. Okay. All right. So if anybody has any questions, feel free. Hey, B. All right, B's here. Awesome. So let's open the floor up for questions. I'm going to wait for you guys to kind of populate it with questions a little bit. So yeah, that's what do you all think? I mean, is this okay? Is this not okay? Is the constitutional infringement outweighs the safety to motorists? Is it okay to place them at greater risk, or maybe not so greater risk, than to preserve the freedoms that our founding fathers have intended for all of us when they drafted the Constitution, and more specifically the Bill of Rights? And the Fourth Amendment, to be even more specific. The Fourth Amendment, of course, protects us from unreasonable searches and seizures. All right. Do I know Turtle Man? No, I don't think I know Turtle Man. Elaborate, Tammy. What if I turn around in the DUI line, Richard? Great question. I already addressed it in a sense, but it's a very important one. In the Cox decision, which I didn't read, that portion is the concurrence. The concurrence goes further. It says, look, the signage is important. It's crucial, and I agree. But I agree for a deeper reason. It allows motorists to turn around. So when they see a sign that says DUI checkpoint ahead, if you continue to drive forward, this is the crux of his argument, you are impliedly consenting to be questioned and to be investigated by a law enforcement officer. If you don't want to consent, I mean, he makes it sound real easy. If you don't want to consent, just turn around. Turn around and go home, right? Or go take a different route. Of course, it's not that easy. An officer always has the backdrop of, I followed the vehicle as soon as I saw it turn around because I had the reasonable suspicion that they're avoiding a DUI checkpoint because they're under the influence. I think there's a case out there somewhere that says that's not enough. But remember, we talked about pretextual stops. So if the cop is smart and he knows what he's doing, he's got a supervisor who knows the law, what they'll do is they'll do the complete opposite. And I hope officers are watching this because, I mean, this is the way to follow the law and still get your impaired driver, okay? If you see a vehicle turning around, all you have to do is wait for it to break the law. Failure to use a blinker, or failure to stop at a stop sign for 3 seconds, or running a red light, or not stopping sufficiently on the white line, improper passing, all of those things. As soon as there is a violation of the law, pretext doesn't matter. United States Supreme Court said pretext doesn't matter. As soon as you have a violation of the law, boom, you got your stop. You begin your investigation, and if the person was indeed under the influence, at least you have reasonable suspicion to investigate, and then probable cause to arrest them once you've conducted your investigation and you've asserted the possibility that they may be under the influence. I mean, that's it. It's really that easy. But a lot of officers don't know that, or they don't care, and they just immediately flash their lights, and they use the fact that you avoided the roadblock as the reason for the stop. Nope. Courts have said that is not okay. You cannot stop a car just because it failed to stop at a roadblock, okay? Because that's the whole point. That's the whole point. The notice is there for you to decide, do I want to go or do I not want to go? Do I want to be investigated? Do I not want to be investigated? Do I want to talk to the cop or do I not want to talk to the cop? That's why signage, as you can see, the Supreme Court was #1 on the list. And because that was violated, even though by my count, all the other 7 factors are pretty much met, they said no, unconstitutional, too much discretion, too hastily done, goodbye. So great question, Richard. Let's see. F. Lotog, thank you for the $5, man. Tell us more about the time you got a prosecutor fired. That's going to have to be a separate stream, F. Lotog. That's a long story. And my voice is already cracking. It's tired, but I remind me, I will definitely tell that story one time. Well, maybe when we're doing something more informal and where I haven't talked for like a full hour and get tired, get my voice. I don't want to strain my voice too much. If you guys can hear, it's already cracking a little bit, but it's okay. I'll be all right. I've been through 2 insurance checkpoints, one in Missouri and the other in Alabama, 0 signage. Well, probably unconstitutional, Dave. Hey, Jeffrey, have you ever been to the DUI college? Yes, I have, on many, many, many times. I'm probably a lifelong member at this point, Dave O'Shea. Thank you, Pug Lover. I really appreciate it. Do I talk about anything other than law? Asks KSBM 1669. What an interesting question. Gang of Four says you will mod for $500 an hour. I'm sure I could find 500 people who will gladly mod for $0 an hour, but thank you for the offer, Gang of Four. What about the location of the stop, says Willie Czar? If they're always done in poorer areas, would that be treating drivers the same? Hey, it's a great question. Never arose. Probably will at some point. How do you turn around from a checkpoint? Just pull a U-turn. Exactly. Joseph Weiss. I can't imagine the founding fathers wanted DUI checkpoints. They didn't even know cars were a thing, but I can see where you're going with this, DJ Fermi. I know this is more of a question, less of a question, more of a demand. Oh, yes, F. Lotog. Remind me when we're doing more informal, like I said. Are you allowed to turn around? I think I already addressed that. Grandmaster level, that's okay. I have enough streaming here. I really appreciate it. DUI, if a cop lies on the stand for a DUI case, how often does the state and the DA go after the cop? Laszlo, the instigator, almost never, maybe 1% of cases, unless you got like a true perjury or something like that. How many clients of mine do I think are actually sober? Northwest? About a third. Not just sober, but had no law violation, were either sleeping in the car or stopped for a reason that's unconstitutional and were actually sober, just harassed by police, just on legal medication, or just below the legal limit but refused. About 1 out of 3 clients I get are actually sober. It's a scary, staggering number, but it's true, and it's rising. It's rising. Because police officers understand that a DUI is cash money. It's all it is. You're just a bag of money to them. When they see and they're like, ooh, I can turn this into a DUI stop. First of all, they get money from the state for every conviction, right? They get money from the state for every conviction that they get. I think it's a few $1,000s per conviction already. Number 2, they get a few hundred, if not a grand, from you, the citizen who got convicted. You know. Number 3, they basically close the door on you being able to find any type of reasonable job that pays well. So they're lowering your likability, thus increasing the chances for other people to find the job. I mean, for them, it's a win-win-win-win-win-win-win. Plus, they're also they receive federal funding for if they have a very high percentage of DUIs filed and convicted versus filed and dismissed or acquitted. So it's staggering. It is absolutely staggering. Oh my goodness. I just got a $50 donation from Sterling. You're the man. I really appreciate it. Holy crap. Thank you. I don't think I've ever received that much in one sitting. So that's one for memory. I appreciate that. Kevin Coburn also with a $20 donation. Sorry, I haven't gotten to those yet. I'm getting to them. Thank you for the great stream lunches on me. Kevin, you're the man. I really appreciate it. I do this for fun. Like I love you guys. I love having fun, teaching you guys stuff. I learn from you just as much as you learn from me. So how many clients have you, okay, I got that. What are your thoughts on refusals when stop at a DUI checkpoint? Absolutely refuse everything. No question. Nothing changes just because it's a checkpoint. Can you cross a double yellow line and pull a U-turn? I would say yes, Joseph. Again, it's all going to be a case-by-case basis. Wild Man now. Okay, Tammy, this is the Turtle Man. Used to be Turtle Man in Marion County, in Marion, Lebanon, Kentucky. He catches turtles, retired now. Many of his crew died in the last few years. His dog. I don't understand what you're saying. I'm sorry. Turtle Man. Do I know a person by the nickname Turtle Man? I do not. If that's the question, then that's the answer that I have. Maybe in the future Saturday night talk about border checkpoints up to 100 miles away from the border. I can. I mean, it's a very short topic, but sure, why not? Can you sing a song? Maybe one day. KSBM. I'm not. I'm not. I'm not here for your entertainment. There you go. Does that answer your question? It actually kind of works double ways. I'm not here for your entertainment, and I just sang a song. So 2 birds, 1 stone. DUI guy 1, KSBM 16690. Actually, you still do get 1 because I did sing a song, didn't I? Okay, we both win. 1-1. All right. What if I'm not from that state and have no idea what Roadblock does? Boozer, you're going to have to check with your own laws. I can't know everything. They can make up an infraction. Yes, they can. Cops lie all the time. What's my favorite handgun? I don't do guns. I've seen cops not using turn signals. Oh, it happens all the time. Try citizens arrest in one of those one day. I'm sure that'd be a trip. Please don't. I'm just totally kidding. Do not do that. That is bad idea. It's amazing how many officers don't know the law. That's reality. Case law is broken. It's all over. It's true. Wish I knew about you to a supporter. Wish I knew about you too, buddy. Do we have to roll down the window when stopped? Okay, so this is a good one. Jeremy M. Collins, do I have to roll down the window when I'm stopped in the checkpoint? Must we open our mouths and speak when spoken to? The answer is no and no. Is it considered being detained when first stopped? Technically, no. So let me just address those real quick. The officers are always going to fall back on officer safety. He didn't roll down the window. I felt threatened. Therefore, I drew my gun and shot at the car. You know, who knows? But probably unlikely to happen that extreme. But do you have to roll down? Absolutely not. I mean, obviously, they're going to set you to the side until you roll it down, and you're going to turn it into a mess. But as long as you at least appear sober, because that's the key. They're looking at you the entire time you're interacting with them. So if you're like, you know, you got your license and your registration, and you're like, I'm not answering any questions. Am I free to go? You know, anything like that. They're probably going to keep you there for a while. But if you're just alert and you're like, look at this. I'm not going anywhere. You know, I'm not rolling down the window. I'm not talking to you. And they're just going to be like, oh, great. It's another constitutional scholar. Just wave them through. Okay, next. You know, next vehicle, whatever. And so it's all, you know, it's all fact specific. It's all what the officer, how much coffee that officer had that morning, how angry is his supervisor, and which part of the country you're in. If you're in Florida, they'll probably let you go, no questions asked. If you're in Kentucky, in Marion County, you're probably going to jail whether you like it or not, and they're going to yell, "Stop resisting," as they tase you. So it all depends on where you are and how it works. So it's very unfortunate, but such is life. Do I carry a gun? No. Sweet or sour? Sweet, of course. Being drowsy is 100 times more dangerous. Absolutely agree. I do like to shoot, though. I do have a DX40. What is it called? DX. I haven't held that gun in so long. I kind of miss it. It's a nice little pistol. Thank you for having these. You're welcome, Tammy. What about the location? Yeah, we talked about that. Till you make it legal. Can you say, I'm not here for your entertainment? No, I got that song stuck. Is that Pink? Who sang that song? I think it's Pink. Saskatchewan, Canada. Hey, Canada. What's the deal with marijuana DUIs? Does that even work nowadays? I don't know what that question entails, but yes, it does work with marijuana DUIs as well. South Jersey, hello, Kelly. Figured as much. I do have a copy of Lawrence Taylor's book. Actually, it's I brought it from the office. It's in the car. I don't have it here, but it's a phenomenal book. It's about 2,000 pages now, so it's a very difficult read, but it's definitely readable. Earlier, I asked if you'll be talking about border checkpoints. Yeah. Raining. Oh, it's not raining, by the way. Thank you for the $20 donation. Dave, thank you for the $2. DJ Fermi. Here are $2 not to sing again. I didn't say I had a voice, man. I never argued that. Joe Shaver, I'm sorry. Thank you for the $10. We'll get to you in just a moment. I'm trying to catch up as much as I can. Keep those questions coming, you all. I'm trying to get to as many as I can. Thank you for the reply. You're welcome, Dave. Really like your content. A lot of stuff from 4 years ago. Do I have any record of recent cases? Well, the courts have been closed, but I do have a couple cases from January and February of this year when the courts were still open. I did have a jury trial set in March. I had like 2 or 3 in April, and I had 3 in May, and all of those obviously got canceled. Jury trials have now been rescheduled for August the 1st, as the first jury trial will be happening August the 1st, and thereafter at the earliest. So unfortunately, I will not have any new jury trials for you guys until the end of summer, more than likely. Because first we gotta set it for trial. We gotta try the case. We gotta order the tape. I gotta splice it and dice it. I gotta upload it, and then I have to publish it. So it'll probably be September before I'm able to upload new content. But I still have content in the works, never before seen stuff. So keep your eyes peeled. I know I've been republishing a lot of cases with new titles, but that's just me running my own sorts of experiments with the YouTube algorithm and whatnot. So just keep your eyes peeled. We'll have a lot more stuff. So again, Sterling, oh my goodness, I finally came up to that comment. It doesn't even have any text. It's just a little wizard pear on a firework. It's pretty cool. Thank you for that. Really appreciate it, man. $50. Holy crap. That's amazing. First time for everything. Second Amendment, where was it? Monetary incentives don't sound like a good idea. Well, I agree, Bing. How does a 40-week class turn a cop into a doctor? You know what I'm talking about, Richard. We need qualified immunity gone. Well, we might have it narrowed down on Tuesday. The Supreme Court is supposed to come back and come down on their decisions on those. They had 13 cases they were looking at. They dropped 3 out. Those 3 seem to be the most extreme, so that's unfortunate. But they got 10 left, so we'll see what they say in 3 days. The 26th, I think, is Tuesday. Yeah, so. I've seen stops with police, on police, and they always refused field tests. Why? Because they know how the game is played, Willie Czar. If a cop asks me to search my vehicle, am I required to answer yes or no? No, you don't. You can just remain silent, literally just stare at him. He'll think you're crazy, but he'll understand. By the way, don't forget to like this video, comment below, and subscribe to the channel if you haven't already. Really appreciate every one of you being here and asking all these questions. It's been a lot of fun, and we're going to keep this going. We're going to keep this going. Can the cop legally search if I remain silent? If they have, I mean, all they have to say, and they can lie, all they have to say is, I smell marijuana. Boom, they have probable cause to get in your car. I mean, it's the easiest thing in the world. Any cop that's been a cop more than a year knows that little trick, and they use it all the time. But if they're a good cop, they may not do it. So you might have that going for you. But evidence can be thrown out if they get in your car illegally. Absolutely, a float dog. Absolutely. New Hampshire, cool, Gang of 4. Refuse everything, including rolling down your window. I would say so, Gelfing. Don't sing. Nice pipes. So we're split. Our circuit, the DUI guy's circuit, is split as to the DUI guy's voice and singing ability. I don't think I have any. And most people seem to disagree. We have a couple that agree. I keep thinking the American cops are allowed to get away with so much because somebody way up high knows that the American public will eventually turn on them. Maybe Captain Freedom. I don't know. Okay, people are talking about guns. I think a couple of members are having a conversation about guns here. Do I believe in a living constitution? As much as I would love to answer yes to that question, I can't in good conscience say that I believe in it anymore just because of all the stuff that I've been through. So I'm kind of biased and I'm the worst person to ask. But I wish it was the case. I wish we could actually have the document as a living, breathing organism that is followed to the letter, but unfortunately we have so much case law that has already butchered it into pieces, and every day more and more pieces are being eroded. All you have to do is look outside and see what people not wearing a mask, how they're being treated, and it's just disgusting. It's absolutely disgusting and abhorrent. But this is the time we live in. This is a natural inclination. Countries and governments always have the tendency to become tyrants and to erode freedoms, to take freedoms away, to make more exceptions to the rules, exceptions to the Constitution. That's what governments do. They have a tyrannical tendency. They have a tendency to be to step outside the bounds of what is permissible, of what the rules are. That's just what governments do. It's not like, oh my God, I can't believe it's happening. It's I'm surprised this hasn't happened sooner. At least that's the way I look at it, because I'm all too familiar with history, and we all heard, history tends to repeat itself, but that's exactly where we are. So that's why we're the gatekeepers of the Constitution, lawyers, and I encourage every single one of you who wants to study the law, even on your own time, to battle your own cases. It's a lot of fun. It can kill a lot of time, especially if you don't know what you're doing. Hey, DUI guy, does Super Chat count as a retainer? No, absolutely not. These are just donations. Nice try, though. What got me into law? I like to help people, and I like to give people advice, and people come to me for advice. They've always come to me for advice. I don't know. I have a knack for understanding people, like basics that most people just don't seem to comprehend. I don't know why. So it seems like they've always come to me, and I just always been helping it. Now I just get paid to do it. So nothing's really changed in my life. It's just before I was just giving free advice. Now I give advice and I get money for it. So it's kind of nice. Plus I get to argue jury trials and argue cases in front of juries, there's nothing more fun than that. One Sean Bond, what about pain medication? What about it? Can you drive on it? Maybe. Do you have a prescription? Depending on the jurisdiction, maybe. I was stopped twice, tag light out, tail light out. My truck looks like somebody they know. Got home, no tag, no light out. Okay. Can you be pulled out of the car and handcuffed for a speeding ticket, first ever ticket? Absolutely, Dave. Unfettered discretion. Love your occasional humor pictures on YouTube. Yeah, so if you guys haven't been following my my community page, I post a lot of memes. I try to limit myself to 2 or 3 a day. But sometimes I'll post a little more. So if you guys like a little humor, even if you don't like or have time for my videos, you can subscribe just for the memes, and it's worth it. A lot of people are saying so. Not everything that I post reflects my opinion. Whatever I find funny, I will share. I know a lot of people find that kind of weird. Like, why would you share something you don't believe in? If I think it's funny to somebody out there, and to most people will find it funny or humorous, or will get some benefit out of it, I will share it, even if I don't believe in it. I don't see a reason why not. Why do I only have to share things like, oh, I have a firm belief in this, so I will share this? Read my about page. The opinions on this page and this channel do not necessarily reflect my opinions as a person, as an attorney, and those of my firm. I mean, that's it. That one disclaimer just covers that entire thing. What about cops not wearing seatbelts? Yeah, it happens a lot. Don't talk to cops, period. Yes. Can you point a flashlight into a cop's eyes if they do it to you? Good luck, Joseph. Roll my window down enough to be respectful and give paperwork. Yep. Oh, crap. I lost it. Where was I? Oh, my goodness. Oh, my God. So many questions. Okay, let's see if I can catch up here. Do First Amendment auditors at this checkpoints do more harm than good? It all depends, Laszlo. It's a hard question. Suggest checking okay. If you are aware of checkpoint, can you turn around? We talked about it. You turn around before you get, yes, we talked about it. I never hunted, oh boy. The conversation, I swear, it's like these people have, go get your own room, get your own chat room, okay? Gang of 4 and whoever else you're talking to. Why are you using my chat room to do this? This is so unfair. No, I'm kidding. But seriously, take it somewhere else. Keep it relevant. Bought a new property to fix, rent, etc., says Joe Shaver. Finally getting to your Again, thank you for your $10 donation. Weed smell is everywhere. Smell stuck on clothes after viewing it. If I'm pulled over or something, what should I say to the officer? It's not me. Yeah, good luck with that. You're still going to get charged probably if marijuana is illegal in your jurisdiction. But it's a hard question, man. You're stuck between a rock and a hard place. Move. Easiest answer. Relocate. That way you won't have weed smoking neighbors. Thank you, Sean Bond, for the $4 Canadian dollar. Thank you. Coffee. Joe Shaver, I'm looking to avoid losing any time times money. Okay. Willie Czar, I wish you were doing civil rights. I do civil rights. People keep asking me that. I represent people in civil rights cases all the time. Car accidents, civil rights cases. Okay. So give me a holler if it's in Kentucky. We can fight your case for you. All right. So those were the paying ones. Let's go back. What? No, not what. When did you become interested in law? I don't know. High school, probably. Tammy. If you're impaired when driving and get pulled over, what should you do? Shut your mouth. DUI checkpoints legal in California? I think so, Stone. I don't know. Check with your own laws. Don't ask a Kentucky lawyer. How many times have your clients been prosecuted for DUI, but instead were just very sleepy while driving? A couple of times. I had that a couple of times, Iman. Definitely. Where are you based in? Wesley, Kentucky. Commonwealth of Kentucky. Government says AA meetings are not essential. And my t-shirt idea for you. That's funny, Ray. Thank you, Bill. Hey, Liberty. Man, you're late. You came in like an hour and a half late. Thanks for telling them that. Cop always say marijuana. I'm trying to avoid losing any time, period. I don't know what that means, Joe. Love it when you tear down cops. Thanks, Jan. They forget that while they can lie to citizens, they can't lie in court. Yeah, because the regular citizens are deciding the fate of my client, and they get to sit there and listen very intently, mind you. You're absolutely right. Did you ever have a case when cops went after someone who made a U-turn trying to avoid a checkpoint? I think I got that call once, but they ended up not hiring me. I don't know what happened with that case, to be honest. In 1997, I interviewed every single attorney who advertised DUI defense. 37 did not have a copy of Mr. Taylor's book. That's funny, Dave. You got a lot of time on your hands. You consult with clients or attorneys in regard to DUI outside of Kentucky? Almost never. Almost never. Man, Tammy is slapping me with the personal questions. I'm done answering you, Tammy, okay? Let's talk about the law. We're not talking about me. How does the entire population need someone to defend them in court? Why? Asks good luck. What? What? Why does... Let me read this again. Okay. Sometimes a question is so mind-boggling. I want the chat to help me out here because I'm at a loss for words. What kind of question is this? Why, good luck asks, quote, why does an entire population, comma, need someone to defend them in court, question mark, why? I'm going to stop that right there. Let me read that again just so you guys are all, in case you missed it. Good luck asks, why does an entire population need someone to defend them in court? Why? There's two whys, one in the beginning, one before. Seems very emphatic. They're trying to make a point here. Why does somebody need to represent it? Why does an entire population need to be represented in court? Chat, please answer our good friend here. Good luck is their name. They're named Good Luck. That's their nickname on YouTube. Why? Please do the honors. Why does an entire population need someone to defend them in court? I mean, why not just let the government steamroll right over you and roll a tank over you Tiananmen Square style? I mean, Why not? What's the point? Who needs defense lawyers when you have the government that can be trusted at every angle? I mean, why not just trust the government in everything they do implicitly, and bow down and say, my good almighty government, I love you with all my heart and I trust everything that you do. Anybody want to chime in? We got some answers coming. Because law is too complicated. It's a decent answer. Come on, folks, you can do better than that. Come on, chat. Chat, wake up. Wake up, chat. Come on. Where are my constitutional scholars here? Fight the power. Constitution somehow protects me. Well, somebody's got to speak for you, right? We need lawyers, that's for sure, says Tammy. Okay. Because we're not Nazis, says Joseph. Okay. Getting closer. Sixth Amendment against us. Really? Government is never trustworthy. Thank you, Christopher Mathis. God, I wish I could give you a super chat. I swear to God. I was waiting for this. Government cannot be trusted. Okay? The government will never be on your side. What have I been talking about? I've been talking about how the government always will have a tendency to become more tyrannical, step outside the bounds of the law, narrow anything that protects you, and widen the scope of attack. Come on. Oy. Sometimes you disappoint me. Thank you, Red and Grimmy, for the $20 donation, super chat. You guys are awesome today. Thank you so much. All right, where was I? Already lost my place because I was aggravated by that comment. But wow, okay. Thank you. Good luck for a 10-minute conversation on your question. How can they call me the cop school? How can they call the cop school an academy? It's just the way it is, gang. Of 4. Qualified immunity needs to be narrowed. I agree. Good question, good answer. That's been a while. I don't know what this is referring to. Can they smell if your window is rolled up? Probably not, unless you have really reek of marijuana. D-Toad 48. I don't care. I'm going to keep my hands in my pockets the whole time. Probably not a good idea. Extortion watchers, you may run into some serious problems if you do that. Hello from Central Florida. Hello, Bill. What do you think about dogs? Dogs is a whole different story. There was a case that came out very recently that said dogs are actually very inclined to, in order to appease their owners, sometimes they will signal even when there is no drugs to be found. They'll just signal because they want to be a good dog. Like, how scary is that? I'm going to be a good dog, so I'm going to signal to my owner that there's drugs because that's what he wants to hear. Horrific. Horrific. Have I ever successfully defended a high BAC blood result? Yes, I have. Stone. What do you see as a solution to the discord between citizens and cops? Better education, better cops, and better education of citizens as well. What are your thoughts on the videos posted on a lawyer being arrested? I actually talked to him. His name's Doug Miller. He got arrested last April for a DUI, which I don't think he deserved. He hired another lawyer here in town, so I told him if that doesn't work out, he can call me. I'm happy to do it. Thank you, Brian. Thank you, Tammy. Okay, AGT, that's a little too much. I'm going to have to remove that comment. I'm sorry. I'm not sorry. Please don't be extremists on my channel. Good singing voice. Thanks, Richard. Later, B. Hold the line. Liberty cause. Good. Okay. All right. I think we're pretty much coming up. Have I ever seen the Pod Brothers at Law? Yes, I have, Lydia. I love those guys. Power does what it wants. That's right. F. Lotog. Carlin said that. History does repeat itself. Okay, we're coming up on an hour 45 here, so I guess we're probably going to be finishing up here in a little bit. If you guys have any more questions, feel free, just drop them in. We'll probably go another few minutes here, and then we will part ways once again. Tammy, stop with the personal questions. Good Lord. Talk about the law. Who's this Tammy character? She sounds like she's from around here. She just wants personal information on me so she can tell all her girlfriends. Ooh, you will not believe what potential husband I have found on the internet for you, Melissa. You know, something of that nature. I don't know. Asking way too many personal questions, Tammy. Knock it off. If a cop says he smells marijuana and he doesn't find any, can he be sued for a Fourth Amendment violation? Sure, but probably don't have a civil suit. You'd probably be able to win the criminal case, Red Bull. Checking from New Zealand. Cool. Hey, New Zealand. Alistar May. I like how you answered my question without acknowledging it. Good luck. We'd spent like 10 minutes on your question. Good luck. For the love of God. I'm not spending any more time on that. Tell me your idea of a perfect day. More personal questions. What best line do I tell the cop when they say I got my law degree in sarcastic voice? Not a good idea, especially if you don't have a law degree. Never tell a cop you've taken aspirin or anything. That's right, Tammy. Ask the cop where he got his law degree. Let's see. Okay, this guy needs to go. Has he been banned yet? A Liberty Cause. Did you take care of this guy? The AGTX whatever. I'm gonna hide him from my channel. He doesn't deserve to stay here. Very nasty comments. Very, very inappropriate. Ask the cop where he got his law degree. That's nice. Yeah. Hey, Gacho Nacho. Have I ever been in, I'm not answering that question, Harley. I was going to hire you as a lawyer, but I'm in Nebraska. Extortion watchers. Hey, man. That's okay. Can't help everyone. Now answer cops. Yes. All right. Let's see if there's anything else. Is it possible to get respect in court if you're pro se? Sure. If you sound like you know what you're talking about and you're educated, which is going to be very difficult to do. But we spend years. I mean, I started my education in law things, if you will, in my first class in criminal law, I think was 2008. So technically, I've been doing this stuff for 12, 13 years. Unless you've spent that much time in your life doing law things, you probably will not sound the most appropriate individual for that position. But if you're appearing pro se, obviously the prosecutor and the judge will cut you some slack. The law should not be that complicated, DJ. Well, it is. So we can't really undo what's been done. How can you donate? I think there's a super chat button next to the emojis, Alistar. Law is too complicated. Okay, you guys were answering good luck here. Yep. What do you use for beard growth? Elvis Hisage. Are you having trouble growing a beard, Elvis? Unfortunately, I think it's genetics. Some people grow it naturally. I started shaving actually very late in my life. So I probably can't grow the best beard that I could if I had started shaving 5 or 6 years earlier. But time. Give it time and the beard will grow. If you got it, you got it. If you don't, you don't. Sorry, bud. Can't have everything in life. Is it possible to look at an attorney's cases that actually went to trial? Sure, just do a search. Stone. I'm looking for question marks. Are breath test results always accurate? They're almost never accurate. Amens D2. That's why we do what we do, because people are being prosecuted wrongfully all across this great nation. You can get just as drunk on water as you can on land. That's funny. Good job, pro commenter. I had a dog single on me when there were no drugs. Oh, I had a dog signal on me when there were no drugs. There you go. Willie's out right here. We got one fresh right in the chat. The next live stream Spontaneity is going to be next Saturday at 6:30. Every Saturday, 6:30 p.m. Eastern, 3:30 Pacific, 4:30 Mountain, 5:30 Central. Can a pro se litigant get respect in court? As I said, yes. Are we just a continuation of the Western Roman Empire? I always keep thinking that in Roboticus. That is such a deep question. You don't even realize how deep your question is. I'm going to repeat it. Are we just a continuation of the Western Roman Empire? And are we going to have the same downfall? Is the rest of that question. I mean, so deep. We could spend an hour just on that alone. Have you ever considered that the U.S. is a bit mental enough and get out to another part of the world for law or for pleasure? I want to go to New Zealand, actually. I've been thinking about that. If I had a place, like if somebody said, look, you have no choice, you have to leave, where would you go? Somebody asked me that the other day, and I said New Zealand. That was the first thing I thought. Number one, I don't know if you guys know, but New Zealand got rid of the coronavirus. They've eliminated it from the island. Granted, it's a little easier to do. They're on an island. Although also, again, don't forget to like this video, comment below, and subscribe to the channel if you haven't already. So it's a lot easier to eliminate the coronavirus from an island. But I would go to New Zealand. I would go to New Zealand and stay there. And speaking of, right as I say that, Alistair, oh, you wanted to donate. That's right. That's right. You wanted to donate. I appreciate the 10 New Zealando bucks. New Zealando bucks. Appreciate that, brother. Thank you so much. I would go to New Zealand. I would go to New Zealand. That's probably be for pleasure and maybe for law too. I'm sure I could pass the bar exam with ease. I've been doing this long enough. I could probably do a bar exam in my sleep. But anywho, that's that. Can a pro say, okay, I'm tired of seeing that question. I love how you disregarded my intent to prompt our people to learn legalese. God said, my people, okay, good luck. You need to chill out. What percentage of DUI lawyers are actually able to go to jury trial? About less than 1%, in my opinion, Stone. I was framed in Illinois. That's unfortunate. 10 days ago. Or no, I went to jail for 10 days. Well, it depends if the statute of limitations is run or not, Gilfing. Good information. You're welcome, Red Bull. How accurate are they? I already said breathalyzers are very inaccurate. Do you have any civil lawyers I can sue a city in Illinois? Not off the top of my head. Get back to me. Shoot me an email or something. Gelfing. I've defended myself from 4 counts of felony charges. Good for you, man. I took 1 misdemeanor charge. Now they have the right to bear arms and defend my family. Good for you. Any ideas on internal affairs? What's my opinion on cash bail? We need to do away with it completely, JC Rays. And it's the movement has already started. We're already on our way there, but we're not there yet. Save your landfills. First Amendment auditors, they're scary, they're crazy, but they're cool, fun to watch sometimes. I wouldn't recommend anybody become a First Amendment auditor, but that's just me. How pained are you watching someone represent themselves? It's cringeworthy. It's cringeworthy. What percentage of DUIs go to trial in Kentucky? 0.000000001%. Thank you for another 10 New Zealando buxo, Alistar. And thank you, Angela, for the 2 pounds. 2 pounds. Okay. I think that pretty much covers the law questions. Looks like we're starting to digress, as always, into a different area, as chat is wont to do. So we're going to terminate our chat here. Thank you all so much for joining me. Today we talked about the constitutionality of roadblocks, and this was really fun. Like I had a lot of fun. We got a chance to read an opinion. We got a chance to cover some California law, some Kentucky law, some U.S. law. It's been fun. It's been really good. I think we had about 100 people just consistently here throughout pretty much the entire stream. It was somewhere between 100 and 150 at its peak. So again, don't forget to like this video if you enjoyed what you've seen. Comment below, subscribe to the channel, hit that notification bell so you get notified whenever I go live or post a new video if you haven't already. It's been really fun. I really enjoyed it today. Next week, we're talking about, what are we talking about? Next week is not June, it's still May. It's going to be May 30th. We're going to talk about pilot, CDL, and boat DUI laws in Kentucky, and that's going to be 3:30 Pacific, 4:30 Mountain, 5:30 Central, 6:30 Eastern. So again, thank you all so much for coming. Thank you all so much for joining me, and I will see you all. I'll probably be posting another video on this Thursday. I hope you have a wonderful rest of your Memorial Day weekend. It's a long one. It's a long one, folks. Still doesn't feel like a weekend because in the midst of the coronavirus, everything feels like a vacation. So a long weekend doesn't even feel like a long weekend. It's just another extension of our vacation. So anyway, have a good one, everybody. Thank you all for joining. And look, we're almost at the 2-hour mark, and I can hear in my voice that I'm already getting tired. So have a good one, and I will see you all at the next live stream. Take care, everyone. Peace out.